Francesca Ippolito from University of Cagliari, Sylvie Sarolea from Université Catholique de Louvain, Anna Trandafilidou from Ryerson University. And unfortunately, I think Francesca will have to leave us right after her presentation because she's been called to perform important duties. And so unfortunately, she will not be there for the discussion, but we will have had the advantage of her presentation. In the interest of time, you'll find the bios of the three panelists in the chat. Also, please ask your questions in the chat. I will be asking questions, so I will collect as many questions from the chat and ask them to Sylvie and Anna, who will be left. And finally, speakers have 10 minutes each. That's in the interest of time. And before giving the floor to Francesca, I would like to have a 2-minute preface to this panel here on understanding vulnerability in international human rights law. And it's a follow-up to the comments that Anna and Maria Grazia made this morning in response to the Italian team. In Objective 16 of the Global Compact on Migration, states committed their term to empowering migrants. And that's the first time I saw that in any official state negotiated document. And it's quite remarkable because for migrants with little social capital, this is the country of what states are doing and state practice. State practice is fundamentally based on the disempowerment of migrants. By not providing, safe legal pathways to labor markets, while pretending to ignore that millions of employers need migrant workers, especially low-wage migrant workers, and that other actors will provide the mobility options that states do not to respond to these labor needs. Also, by actively tolerating unacknowledged underground labor markets where exploitation is rife, by creating programs for temporary migrant workers where exploitation is often institutionalized, and by making asylum procedures more and more difficult and often inaccessible, as Lira has well explained in the previous session. So despite their considerable agency, and I mean considerable agency, migrants are made vulnerable by state practices and policies creating precarity of status, empowering exploiters, be they employers, recruiters, lodgers, smugglers, or corrupt officials, and in effect, by subsidizing exploitation. Subsidizing the lowest wages possible, for example, and the reduction of labor costs. Precarity has become a migration governance strategy. Migrants cannot use the political voice, the citizenship-based political voice that industrial workers of the 19th century, women, indigenous peoples, the LGBTQ+ community, persons with disabilities, or detainees have used to empower themselves and fight for their rights. Without the political clout to force politicians to listen, migrants' voices are silenced by the fear of deportation, which is the key of this state-created precarity. And this policy and practice of disempowerment of migrants reveals a willful refusal to effectively, not simply in words, but to effectively implement the human rights framework to migrants. And this is my segue to give the floor to Francesca.
Thank you very much to the chair, Professor Krippel, and thanks to all the Vulner project group for the invitation and the opportunity of sharing some thought with you on vulnerability, not only in the context of migration, but maybe at a larger extent, trying to see if this state-imposed vulnerability, to which Professor Krippel has just made reference, is in some way shaped also in international human rights adjudication. And so if courts using this concept of vulnerability are responding or can offer some response to this disempowerment also of migrants. So understanding vulnerability is not an easy task, because it's confront us with the understanding of the real nature of human beings, and it has always been a controversial matter. But vulnerability migrates itself from the context of philosophy, where it is understood as an enduring aspect of every human being, so a status of sharing a constant exposure to potential harm. That is a concept that we have deeply experienced it during this pandemic, has moved in the legal context with some different meanings. And so understanding vulnerability in international human rights law, which is the task I have been assigned for today, is not a less difficult task, because it confronts us with theories of responsibilities, positive obligations, and due diligence. But vulnerability has progressively become a recurring notion that is not so unuseful as it could be at first sight as a vague concept, because if we look at the practice of quasi-judicial bodies, so the UN human rights bodies and the regional human rights courts, but also at international instruments, we see that in legal terms, vulnerability permeates international instruments for the protection of human rights, and it shapes international human rights adjudications. How? It is a reference of the parties, and it is in the descriptive and rhetorical moment of the decision, but it is mainly used in the interpretation and the application of conventional provisions. And for what I see, the main role of vulnerability is a role of regulatory criterion of the specific canon of interpretation of human rights treaties, that is the principle of effectiveness. So for granting human rights treaty provisions, the realization of their object and purpose, and so allowing human rights provisions to attain their appropriate effects. And possibly, in vulnerability in international human rights adjudication is introducing a developing nature of a human rights general principle. So starting to see vulnerability as a regulatory criterion of the principle of effectiveness, we can see that a vulnerability regulates the effectiveness of two parameters of state responsibility. So mainly vulnerability influence the threshold of harm, and so it impacts on the seriousness of risks, because the risk is perceived differently depending on inherent characteristics, for example, ages, or external and societal factors, so disability, ethnicities, but also this migration status, and so this is state imposed vulnerability. Vulnerability is used to presume risk in cases of migrant children, or it appears for downgrading the severity standard in the case of extreme poverty and asylum seekers. And it has been used to lowering the national margin of appreciations in cases of exceptional circumstances for Dublin returns. So leaving aside the impact of vulnerability on the seriousness of risk, and considering the other impact that is on state conduct, so in this other element of state responsibility, vulnerability impacts on national due diligence. It impacts on legislative due diligence because it calls for deterrent legislations and policies to govern private behavior and curb abuse, and thus punishing perpetrators more severely and reducing the likelihood of violations. And this, for example, has been seen through the enactment of criminal legislation for deterrence. But vulnerability is also impacting on administrative investigative due diligence, for instance, favoring the development of protective measures to ensure the reliability of evidence, preventing it from becoming the source of further harm, such as in the case of children vulnerability, but also possible racist motives for acts of violence, which might be difficult to prove, and sex trafficking. So vulnerability as a regulatory criterion of the principle of effectiveness helps in developing a variegated range of positive obligation on both sides of procedural and substantial meeting of special needs. And vulnerability also impacts a posteriori on the redress side, modulating, for instance, the access to international justice, adjusting with favorable interpretation, and this has mainly been the case in the European Court of Human Rights jurisprudence, adjusting with favorable interpretations the standing of victim before international judicial bodies, but also before UN human rights bodies. And it reinforces guarantees of the right to be heard and as a modulated compensatory obligation of states, and this mainly in the inter-American system with a variety of new types of compensatory obligation, also, for instance, for training for some immigration national authorities. The advantage of the development of this criterion, what could be? In my opinion, that vulnerability could be a possible beneficial guarantor of universalism of human rights by deconstructing the notion of autonomy and independence as implicit assumption of legal subjectivities and stimulating the identification of norms and policies that take into account a complex subject rather than an abstract and stripped down subject. Vulnerability could better ensure the tailored enforcement according to the need of anyone whose fundamental freedom are perceived and accessed or harmed differently. Vulnerability better declines who everyone is in every situation of life, showing a myriad of differentiations so that in the wake of the idea that the most universal quality is diversity, universalism of human rights could be better pursued. And not less significantly, vulnerability performance as a regulatory criterion of effectiveness helps the concrete universalism of human rights insofar as it corrects the still aspirational forms of universality of human rights from the dimension of individualism, which misses the dimension of sociality, positing selfish and isolated individuals who assert what is there rather than participating in communal life. Come to the other role for vulnerability, because vulnerability, it is not only explicitly or implicitly acknowledged in many international human rights texts, but mostly in human rights jurisprudence, it has been developed a lot. It is also possible to imagine, not for vulnerability, but this time for protection or respect of vulnerable groups, the nature of an emerging human rights general principle. It has not been excluded for the international jurisprudence to have not only a role of transposition and recognition of national general principle in international law, but also a role of constitutive source of general principle. That it was, for instance, the case in Lagrange, when the International Court of Justice formulated the binding charters of order for provisional measure, and it gave particular weight to the existence of a principle which has already been recognized by the Permanent Court of International Justice in the electricity company case. And on the other hand, in yellow, in order to decide on the general principle governing on compensation, the International Court of Justice refer extensively to other general, to other international courts and tribunals, such as the International Tribunal of the Law of the Sea, or the European Court of Human Rights, or the Inter-American Court of Human Rights, when applying abstract principle of compensation to concrete cases. An International Court of Justice has recognized that the construction of Article 38 of the Statutes of the International Court suggests that recognition of general principle within international adjudication seems sufficient, at least at the initial stage of the principle formation. So this approach, in my opinion, leaves room for the introducing of general principles that fulfill the aspirational demands of international law for fostering community interest and functional approach. So if that would be the case, and this initial phase of use of vulnerability notion in international human rights practice will be confirmed, and the protection of vulnerable groups performs and continue performing a proactive function in the degree of protection and enjoyment of human rights, the respect of vulnerable person could be retained to stem within those general principles that ensure guidance and coherence in legal interpretation by reference to a set of values, but also dynamism through theological interpretation, positively contributing to concretize the content of other principles, such as equality principle or the principle of human dignity, by reference to standards capable of positively affecting individual resilience. Thank you.
Thank you very much, Francesca. I don't know how long you'll be staying with us. Can
just
you?
For other 15 minutes, I can.
Okay.
Then I will be at the court.
Good. I'll now give the floor to Sylvie, I think is next in line. Go ahead, Sylvie.
Yeah, thank you, François. Thank Francesca and all of you for inviting me to react, or maybe to give another point of view, quite different point of view, or to illustrate this point of view, this analysis of vulnerability, but coming back, and very sorry for that, to the asylum procedure. Because what we learned from the Vulner project, asylum being they're seen as a laboratory for other procedures involving weak users of procedures to ensure respect for fundamental rights. What we learn is interesting for vulnerable people, even out of the asylum procedure. Firstly, what we learn is that most of the time, and it's not only the case in asylum procedure, but also in other procedure, is that vulnerability is understood by the legal framework and even in the field as an ontological concept. You are or not minor or adult, victim of torture in the country of origin or not. Secondly, ontological, but also decided at one time in asylum, the arrival in the reception country, and in relationship to one place, one territory, the country of origin. Thirdly, that the different legal instruments of the common European asylum system identify certain factors as indicative of vulnerability in various ways. So the system is fragmented, encouraging several field actors to work separately. And lastly, even better understood, what could be the consequences in a system where finally in the asylum procedure, and again, it's the same in criminal, international criminal procedures, in a system where you fulfill a legal definition, here the definition of a refugee or not. For instance, in the asylum procedure, at the reception, at the level of the reception condition, maybe if you are on the basis of an ontological definition of vulnerability considered as vulnerable, maybe one will avoid during a certain period of time to mix the applicant. No woman victim of violence, sexual violence in a center full of men. I am caricaturing, but not so much. Secondly, at the level of determination, maybe one will authorize a woman to refuse to be interviewed by a man. Okay. At the level of appeal, it becomes more difficult because most of the time in immigration, the procedure is formal, written, and the judge doesn't have a real power to investigate when he faces a weak person, a weak asylum seeker, and this person could be lost at this period of his life, and a person without any evidences in the file. But it is not a ground to receive a refugee status. And again, I will make a caricature, use a caricature. The best is, but I have experienced that in my life as a lawyer, the best is that the judge says, oh, what a pity. If necessary, take a legal action against the center or against your lawyer, because you were badly advised, but it doesn't make you a refugee. So to avoid that, how can we approach vulnerability in a holistic way, but also in a way that empowers the person concerned, and a way that doesn't lock her or him into a definition that calls for solutions that give a good conscience, but doesn't produce the desired effects. To empower a person, you must know why you try to identify factors of vulnerability. What is the purpose of this specific assessment? If it is only to fill a questionnaire, or is it to empower this person at one specific period of her life to face a difficult process, for instance, the asylum procedure? On the one side, if it is to fill a questionnaire, vulnerability will be only an instrument designed to qualify someone alone, to qualify a person. On the other side, a useful understanding of vulnerability is an understanding that aims at empower this person in a relationship to another person, or more widely to an institutional system. And a concept that empowers and develops, encourage the agency, and not a concept to design or to put someone in a box. I will use two examples in the international human rights case law. The first one, and those of you who knows me will say again this so case. I use this case as an example, and I have to confess that I was the lawyer of Mrs. So, but it was a long time ago, and now I try to have an objective analysis of this case. Mrs. So was a Guinean woman invoking a risk of genital mutilation in case of expulsion to Guinea. She was involved in the second asylum procedure based on a new medical certificate saying that there was a risk of a new mutilation since the first one was not successful. There has been in the past an attempt of FGM without finishing it in Guinea. This second application has been refused because it was considered that the medical certificate of a specialist, a gynecologist, wasn't considered as a new evidence. She should have produced it before. So she wasn't considered vulnerable during the procedure. By the time she arrived in Belgium, she should have known the right specialist who would have been able to recognize a successful or a failed mutilation. But how can, in the reality, an asylum seeker be expected to find the right doctor once arrived in a new country, maybe even with a new language, without any autonomy? When you are in the center, you are not free to decide, I will contact a doctor, and you are not able to find the right one, the better specialist. But both the Belgian judge and the European Court of Human Rights refused to consider her vulnerable to the risk in Guinea because in leaving her country, she showed strength of character. And of course, Mrs. So was very strong, and she's even, in my view, a hero in modern time. But in the relationship to the asylum procedure, to a new procedure, and the necessity to bring a lot of evidences, she was vulnerable. And she was also vulnerable in relationship with the Guinean society, in which there are a lot of discrimination against and violence against women. And that is why we advocate that vulnerability is multi-dimensional. That's one point. And secondly, must be used as a concept to empower the person and not to define a person at one time in a certain place. And there are a lot of examples that we could use. And on the contrary, a woman who has been sexually abused will be able to cope better sometimes in the procedure, thanks to a quick identification and assessment as vulnerable, and thanks to adequate care than an isolated man separated from his family under financial pressure and so on. Everything will depend on the context, on the environment. Vulnerability cannot be limited to one place and one time. Once arrived, it originates in the country of departure, is influenced by the migratory trajectory, which will be emphasized by Anna, I think, by the reception conditions on arrival, by the way in which the procedure is organized and experienced. Again, as a lawyer and in the field work, in this research, we discovered, we knew that, but it was underlined a lot of time that when you arrive as an asylum seeker, you are placed in an isolated center, or maybe in a very new modern center, but without a connection, or in a vast center where it's impossible to keep calm, without a connection to a cultural community. When you arrive in crisis time, you will become vulnerable, but not vulnerable because you are a weak person, but vulnerable because you will not be empowered to face this very difficult procedure that aims to decide if you are a refugee or not. And also administrative factors will have an influence, like the length of the procedure, the difficulties to find a translator, a good translator, the difficulties in the relationship with the lawyer, or the relationship with the lawyer is so important since most of those immigration and asylum procedures are written one. I have another example if I have some more time. This second example is based on the very recent decision of the Committee of the Right of the Child of last, not so recent, but September 2020. The Committee of the Right of the Child ruled that a Dublin transfer decision taken in respect of a family, it was a mother and two young children, if I remember well, from Uzbekistan. This decision of transfer violates the International Convention on the Right of the Child. And the reason why there was a violation, it was decided that there was a violation, is because the children have not been heard. They have not been heard to explain to the judge what they were thinking of this decision, this new decision of transfer. So it's interesting to say that the children have to be heard about the trauma caused by this transfer, but they were 5 years old and 9 years old or 11 years old. They were very young. And for me, it's not clear why and how to hear the children could limit the trauma, since the authorities were very duly informed of the difficulties of this family to move again to another country, to be transferred again. The file had been documented by NGO, field workers, and a lot of persons. And
Conclusion, Sylvie, conclusion.
Conclusion. My conclusion is that in that case there was another complaint, and another complaint expressed by the mother, but the committee has judged that the domestic remedies for this complaint had not been exhausted. It was the extreme violence of the police officers who came to wake the family at night for a transfer to the airport. And the consequences of this violence on the relationship of trust between the family and the authorities for the continuation of the procedure are much harder than the facts to have not heard the children. And if you want to empower the family in the asylum procedure, the authorities must build trust and not mistrust. That was what I wanted to highlight, is that vulnerability has to be considered as a concept to empower and to build trust between one institution or a country and a person facing this country. Very sorry to be so long.
That's all right. Thank you very much. Francesca, if you have to go, you go when you want. Okay. Anna?
Yeah, I don't know if Francesca, because I know she has something else to attend. If you want to react to Sylvie, and then I can give my comments.
Go ahead.
No, I give you the floor, because I'm really in a complicated transfer now. So I just leave on all and if I be able to find another moment later on, I will react later on. Thank you very much, Anna.
Yeah, no, for those who don't know, I think you're in the process of examining new lawyers.
Yes. Some people
cognitively, emotionally, probably, demanding. No, thank you both. And for me, it was a great pleasure to reading your book, Francesca, because I think I learned a lot in terms of how vulnerability can be used by lawyers, and trying to bridge this. I think Sylvie already has done a little bit of that, trying to bridge the more legal reasoning, or if you want abstract reasoning with what happens in reality, and how we can use the concept, which is what the Vulner project and the consortium are doing. And I think partly Sylvie already has given the response to a question in the chat, which is, and thank you, Jamina, for this question, which is, how does can vulnerability be, how can I say, compatible with power and with being strong? And I think, Sylvie, you asked this question because you said, so why do we do a vulnerability assessment? We do it to then put the person in a condition to be empowered. And I think Francesca is also very well analyzing this in her book, speaking of resilience. I come to vulnerability, I have to say, from very much a sociological perspective. So what does it mean on the ground? If you want, in a way, yes, vulnerability on the ground does not mean empowerment. It means rather I give some particular attention to people who are perceived as weaker, as more vulnerable. And I think on the ground, it has become even a substitute for deservingness. So like minors, they are vulnerable in a way because they are deserving, because they have no responsibility and they're not to blame. They're not guilty of anything, because even if they come, through the borders unauthorized, or their parents submit also for them an asylum claim that is not well substantiated, the minors have no say in this. So then there is this other kind, so that I think on the ground there is something in vulnerability that comes with deservingness, with a hat of deservingness. And I think probably that's the question also of people who suffer from important mental or physical health impediments. So again, there is no guilt, there is no responsibility from their action. It just happens, whether the problem was, they had it, how can I say, they were born with it, or it was caused by something during their life. And then I think we have this on the ground, this different notion of vulnerability, which is, what is codified, say, in documents like IOM's, guidelines, as situational vulnerability, which is probably the one that is more gendered and is generally applied to women. So you are in a situational vulnerability because you're a woman, and if you're transiting, of course, the obvious example is Libya, but it doesn't need to be Libya. It can be also, Central America and Mexico. It can be Venezuelans fleeing to Colombia. It can be different places, including, of course, in Europe. Then you are vulnerable because as a woman, you have more chances to be subjected to, to sexual abuse of different sorts. Or in that case, actually, the situational vulnerability is not. So for instance, young people, including young men, who out of situational conditions may be subjected to severe exploitation, for instance, labor exploitation. They're not seen as vulnerable because in theory, because they're young and they're male, they can react to it. And what we have seen, I think, in recent years is a higher sensitivity to say, even people who do not have this individual, a priori attributes can have this vulnerability, situational attributes, because we define vulnerability also as the absence of viable, alternatives to the situation you are subjected. I think what I want I think what I want to bring to the discussion is how indeed we can bring the legal concepts more to the benefit of the people on the ground. Is really, I think, to ask the question that Sylvie has asked. So why do we implement a vulnerability assessment? And certainly this is something to be implemented within the asylum process, but also outside the asylum process, because people can be vulnerable also without being asylum seekers. The second thing is, and I'd like to hear other thoughts on this, something that has been really, how can I say, puzzling me, and on which I have been thinking and researching, taking my interest, particularly from the people who are going through Libya and the practice that is followed in Italy. To give them, we discussed this earlier in the closed workshop, the practice in Italy to give them a humanitarian permit through various, I would say, legal meanders, through various pathways, recognizing that these people probably were not vulnerable a priori, were not asylum seekers, so they have no good grounds for international protection, but simply by going through Libya, they suffered such extreme hardship that they were made vulnerable so during the transit and upon arrival, they were made vulnerable. And then I don't want to now go into the details of the Italian case, how judges and lawyers have tried to make a case that if the person is settling down in Italy, has been actually, they've, how can I say, they've grounded their approach more on a comparison between the settling down in Italy and the harm and the risks that they would suffer if going back to the country of origin, and say, okay, their fundamental rights would be violated and we have to keep them here. And then the question for me is also rising whether vulnerability is a relevant concept there or not. Because I was wondering, maybe we don't need the vulnerability concept, and we simply can say, parallel to the asylum protection, we have a system of humanitarian protection. And it occurs to me, for instance, also in Canada, we have a permit that is called the compassionate or humanitarian permit, which is given to people who are not entitled to asylum under very specific circumstances that are actually both very open and very closed. They're not specifically defined in the law, to capture those cases, in my understanding, of where the state, in an ethics of care, as Francesca analyzes in her book, says, okay, I need to cast my net and get these people in and protect them. So I think I would want to stop at that, and yes, basically ask these questions of exactly how do we match the legal definition with a practical definition of vulnerability, and then how do we implement it to cast the protection net wider, even when there is no clear case for asylum.
Thank you, Anna. Very, very interesting. Francesca, since you're still there, do you want to react to both comments?
But I just saw in the chat one question that maybe is deserved, because it maybe helped me in doing a whole or a comprehensive, trying to make it comprehensive answer about what are, so sorry, why is that human rights courts as well as legislator increasingly making use the concept of vulnerability? So is this a political discourse or influence of other disciplines? I think that is a combination of both things, and also of a reflection also of the new, not new, but the most recent human rights instruments, for instance, for older persons, or instruments adopted in the context of the inter-American system, that where these terms of vulnerability or the protocol for trafficking becomes explicit. So there are legislative instruments where, you know, the words find its place, and so emerge from the ground and the rationale of all the human rights instruments. So but also because, you know, other disciplines are involving a discourse analysis, so legal theory or sociology. Sociology maybe is the first one that has been involved with this development. Anna could better explain than me about this concept of vulnerability. But then, you know, there's a cross-fertilization about, you know, experts in the human rights bodies that are not judges. So I think is a mixture of things that has, you know, making emerging the concept, and that probably will influence also its use, because there is also a cross-fertilization, a cross-dialogue among courts. And so the European courts has influenced the Human Rights Committee and vice versa. And now this is replicated also for this vulnerability to climate change. So I think that that is also, for instance, in Italy, we have a deep reasoning on these humanitarian grounds for climate-induced migration. That is for the Supreme Court. And this is a movement also that is, so I think that maybe it is difficult to discover if there is one real point, but it is interesting that many factors are probably pushing in a direction of reshaping, you know, and also this pandemic could help in reshaping, you know, the importance of human rights and the third generation and second generation rights compared to the first generation, if it is still actual distinction. Thank you.
Thank you very much. There's another question by Jamina about the right to give, the concept. Do you think that the concept of the right to give, which emphasizes people's agency and capacity to contribute, could be enshrined in more documents as a way to make empowerment of migrants more official? I want to add that you have mentioned, Francesca has mentioned the question by Tim in the Q&A, and Anna has mentioned the second question of Yamina, but the first question remains unanswered. Has any one of you an idea?
Maybe I could say that it's interesting, but it could be interesting. Maybe it's a concept that could be welcome in the Canadian system, where immigration, maybe it's not so simple in the reality, is quite welcome, but in a system where immigration is considered as not welcome, they say, okay, you have something to give, but we don't want this thing that you would like to give. And the system is not built to empower migrant to give something, because the only answer that is given to the migrant is, okay, maybe in a compassionate approach, if you are a refugee, we have to welcome you and we will do it. But if you are coming to give something, we don't want, because we have unemployed person in our country, and we don't want immigration more since the 70s. So there is no place for this kind of argument, and that's the official discourse. In the reality, we know that there is a place for that. And during the pandemic, it was quite clear that a lot of migrants were working in care, in relationship of care. But when we asked to the minister, not the minister, but its Secretary of State, to give permit of stay to regularize all those migrants working as nurse and so on, even we didn't receive any answer, even not a negative answer, no answer, nothing. So this right to give, there is no right to give because there is nobody to say, okay, we would like to receive something. The only answer, official answer, we don't want to receive something from migrants. That's the official discourse.
Anna?
Yes, I was just writing the chat, Francois, and I'd like to intervene. Yeah, not so much on the right to give, but on the wider question of vulnerability and how it relates to agency or resilience and empowerment. I would like to reiterate my point that I think on the ground, and I referred to that earlier, that there was this, in my view, very, very enlightening non-academic article of refugees deeply 3 years ago, which was called The Vulnerability Contest. And it was highlighting how vulnerability was, yes, an advantage for women and children and single-handed families and people who were invalid and so on and so forth, but it was creating almost a negative, a disadvantage for people out of their individual traits. And again, I will repeat, basically being young and male. And what this article was showing is that it was speaking about a few young men who arrived at Lesbos in Greece while minors. They were of Afghan origin. They were born and raised in Iran. They had been at some point arrested as undocumented, and they were given this option: go back to Afghanistan or go to the army and go fight ISIS. And of course, that was the option that they took. They were sent in some sort of almost suicide kind of squadrons. They survived, they escaped, they transited to Turkey and then to Greece, seeking a way to Europe. And the question was that these two journalists / researchers were raising is that these kids, upon arrival at Lesbos, were advised, I think by other asylum seekers, to pretend they're not minors, so that they would have more agency in not being sent to the shelter, not being placed under protection. Because of course their wish was, I'm not sure, I don't remember if these particular kids had family somewhere in Europe or other relatives that they were joining, or simply they were trying, to make a life for themselves in Europe. And so they were not, they were vulnerable by our assessment of vulnerability, but they did not want to be vulnerable because they wanted to continue their journey. And the system was probably penalizing people like this who were vulnerable by both, not so much by individual, but by situational vulnerability. And again, I don't know, I have this bug in me which says that vulnerability is very much related to deservingness, as if it creates a sense of deservingness. And again, I think I'm inspired in this, or informed, my thinking is informed by the case of Italy, where there is really high protection for minors, including undocumented minors, not asylum seeking minors necessarily. There is high protection for ill people in the migration law for people who are very old. So again, individual vulnerability. Then I would say that there's high protection for mothers and parents, because it is expanded to not only women who are pregnant and women 6 months after birth with a baby, but also their partners, including non-married partners, provided they are the effective partner of the woman, where the vulnerability, and if you want, the deservingness, emanates from the baby, the unborn or just born baby. So going back to the minor. And then you have the situational vulnerability or deservingness that is arising out of Libya, basically. And this is where, I mean, maybe some of you who are listening to us are familiar with the Italian case, where the courts are trying to provide protection to people who did not have a valid asylum claim upon the country of origin, their situation at the country of origin, but who suffered damage, physical and mental damage, while going through Libya and being faced with abuse. So they have become vulnerable, so they deserve to be protected. And again, I wonder to what extent there is a morality of deservingness, which does not relate to agency, or there is a moral duty of care in relation to vulnerability in order to make you resilient and empowered and able to go ahead with your life.
Thank you. I don't see other questions, and Francesca and Yamina have left the meeting, but maybe I have a question. Do you find that my distinction between vulnerability and precarity is analytically useful? I have tried to separate the fact that people are vulnerable because of personal characteristics, being a child, being ill, having a disability, or having, sustained a trauma, and the fact that the state constructs a vulnerability by using policies and practices that actually disempower migrants even more. Like, for example, the fact that we tolerate underground labor markets by the combination of migration policies that are repressive and labor policies that lack oversight. And this combination creates a system where millions of people are exploited in underground labor markets. And we know that, and states do not do anything about it. And that silences them, that creates an additional vulnerability. Is that distinction between constructed vulnerability, that I call precarity, and personal vulnerability characteristic, is that useful analytically? I mean, in the end, for the individual, I mean, being silenced is being silenced, whatever the cause, but is that useful analytically?
I have my views, and actually it's very good you remind us of your introduction, but maybe Sylvie wants to go first.
No, please.
Yeah, very good. I mean, actually it impressed me when you said it in the introduction, François, but then I kind of, I got carried away from Francesca's. So I have a problem with precarity, and particularly in the way the precarity is used in the Canadian research, because it becomes, okay, and of course my view is quite informed by the European realities, is that, so in the Canadian research, somebody who is precarious can also be a legal migrant or an asylum, a legally staying asylum seeker, also a refugee. Maybe a refugee, yeah, because precarity is used to mean temporary status. But if we take away temporary legal status in Europe, there's hardly anyone left, if you see what I mean, precisely because, as I think Sylvie or Francesca were saying earlier, it's a different reality. So this is my concern, that precarity risks diluting what we're talking about, because someone who is a construction worker with a temporary permit in Canada is a precarious migrant. Now, the other question is, yes, good point. Is it state constructed vulnerability? Yes, of course. Again, with a question mark of where do we stop precarity and where do we start temporariness? Because I don't accept that all temporary staying migrants are precarious in the sense of vulnerable. Because I think, yes, it's a very good point. Precarity, I think, certainly has an element of being vulnerable, not having agency, but not being able to exercise your agency out of situational elements that, you're very right, are probably largely state created, but also market created. But then the question is, if you say, in North America or in Europe, we tolerate irregular work in agriculture, in food processing, in construction. If we close down, if we crack down on this irregularity, the price would be probably higher for the migrants or the asylum seekers who are working than it would be for their employers, at least the immediate cost of this. So I'm a bit worried that it may backfire. And on this, I would like also to add, there's been this criticism in relation to migrant smuggling. And there is some research that states that when people were going through the Balkan path, from Turkey, Greece, and further west and north, the border controls were creating more insecurity and more vulnerability than the smugglers.
Yeah.
Now, I find this problematic because we cannot expect that anyone will say, okay, let's do away with the border guards so we eliminate the vulnerability. So I find that we may be pushing our arguments in non-productive directions, if you see what I mean. I don't know, I'm also realistic in I think what we can argue.
Yeah, I think we need to have a different conversation some other time, because I'll have many answers to this discussion. There is a new question right now. State of need. C question. Let me see if there's something. Yeah. Conceiving vulnerability as state of need, similar to precarity, wouldn't be useful in order to avoid problems of assessment of vulnerability, especially as regards the situation in the country of origin later transformed. And at the same time, for bridging the gap between sociological and legal notion, would it? State of need.
But I would say that it depends on what kind of need. And again, it's the same as for vulnerability. I think that if you consider vulnerability as a definition that puts somebody in a box, it could be interesting, for instance, for minors. Okay, we say that minors, we consider that they are vulnerable because they are minors, okay. But after that, it will depend on the situation. Each person will have specific need at each stage of the procedure, but depending also how the person is experiencing the procedure. There are so many ways to experience the immigration procedure, the asylum procedure. It will depend of the people you will meet. Some people will meet, and it could be the hazard of the life. They will meet a lot of volunteer helping them or not. And I think that's why we prefer to one definition, ontological definition of vulnerability, a three-dimensional definition of vulnerability that takes into consideration, okay, ontological definition, situational definition, and administrative one. And one of my propositions, but I didn't have time to explain it, is to use in the immigration procedure as well in the asylum procedure, each person would have a right to have a mentor, an independent mentor that will follow the person during the procedure since the beginning and during the whole procedure, a mentor able to have a complete figure of the person and to be a person of a contact between the authorities and the person. And maybe this person will be able to say, okay, I knew that Mrs. So was unable to find the right doctor at the right time. So I think that the most important problem, maybe it's this precarity, but this precarity linked to the mistrust created between the migrant and the state and the institution. And that's the main problem following me.
Thank you. We are 2 minutes to the top of the hour. Luc, do we have permission to go beyond, or is that a cutoff time, absolute cutoff time?
No, you can go beyond.
Okay, then we do. Anna, comments on that?
My comment was I wanted to invite you to share your input on the discussion.
Oh, yes, you did that.
Abuse your position
as chair. Yeah, I was hesitating. I already did at the beginning. To me, I think you're right to say that if we implemented from one day to the next labor law fully to migrant workers, whether undocumented or temporary, we would wreak havoc in the economy. That's why I think what needs to be done is to do with, you know, migration policies, what we do with all other policies of government, you know, energy security, food security, healthcare, education. We do strategic planning for 20, 30, 40, 50 years. And we never do that with migration and mobility. We never have big discussions about the demographic needs of Italy by 2050 or, you know, 2100. We don't do that. We don't do that in any country, not even in Canada. The Canadian government does not speak of demography, when I think that Canada wants to have the same population as France and Britain and Italy before the mid of the century, but it's not said in official documents. And this is the kind of conversations we should have with the population in order to educate the population about the complexity, the variety of issues. And if we do that, we can say, then 15 years from now, we want to eradicate exploitation in the construction and agricultural industries. And the steps we'll take will be the following. And we're not going to do that from one day to the next, because that would kill, you know, 2/3 of the farms in Canada. But we're going to do it over 15 years. And the first step is to, first of all, have labor inspections that actually work, which most countries do not have. And second, to ensure that we have a regularization program that allows people to have more permanent status, so that they can claim their rights and not fear being, you know, detected, detained, deported, whatever. And that applies to both undocumented migrants and temporary migrant workers. It applies to both. And when I say temporary migrant workers, I always have the caveat that it's temporary migrant workers who lack social capital. The Canadian engineer who's an expat in Dubai is a temporary migrant worker with a 1-year permit, but has social capital, and most of them can leave. Sometimes there's a blip, but most of them can leave if they're not happy, which most migrants with temporary migrant worker status in construction, agriculture, mining, fisheries, care cannot do, because they have family duties, they have pressure to reimburse debts, etc. So to me, the idea, and that come back to the distinction between precarity and vulnerability. To me, precarity is state created precisely because states do not want to start a conversation with their population about the long-term objectives of mobility. And the long-term objective of mobility should be to allow people to go where they want, where they will thrive and bring something to their society. That relates to the right to give somehow, but also respond to the needs of the employers, but within a regulated labor market over time. Within 15, 20 years, we will have a quasi, not, you know, there will be always margins, but we will have a much better regulated. We have at present millions of people who live beside the law. They're not protected by the law. And that is abnormal. That's why unions were created in the 19th century, because all those industrial workers were not protected at all. And unions have not been key actors for protecting migrant workers, be they asylum seekers, be they temporary, be they undocumented. And unions are beginning now in the agricultural sector in particular, but also in other sectors, to consider these people as future members, but it's very slow. And so that's why I use the distinction between vulnerability and precarity in order to show that the vulnerability has to be dealt with, but precarity could be essentially eliminated if we changed policies over time, taking into account the investments that will be needed in order to subsidize, for example, the farms to do the transition to a non-exploitative mechanism. And that it will involve increased labor costs, absolutely, and increased costs for the consumer over time. I mean, that's my explanation, but is that any useful?
I think we need a small footnote for those who are not familiar that Canada has 35 million people. And there is something called the Century Initiative, which is an initiative largely of entrepreneurs and, you know, some stakeholders to grow the Canadian population by 2100 to 100 million. Yep. Now, I suppose, Francois, both you and I might agree, and Delphine in the chat, that this might not, I mean, it's more an aspirational goal, but as Francois was saying, there is a feeling that Canada should increase its population. But I think there, yeah, we don't have this kind of discourse in most European countries, even if several countries are facing the same aging society challenges and worries about how many workers per pensioner, etc. But I think, I think this is probably an important thing that you said, Francois, whether we need to think of precarity as a concept and how it relates to vulnerability is and you know, state constructed vulnerability. And I liked also Sylvia, I think what you proposed, like ontological, or if we want, individual ontological vulnerability, situational and administrative. Yeah, I think that makes absolute sense to me.
Good. We haven't solved the issue, but we've discussed it. Luc, is it time to close? I don't see any other question. There was a comment by Alberto, but not a question.
Yeah, I think so too.
Yeah, it is late for you. For us, it's the middle of the day. It's okay, but for you, it's late. So thank you very much, everyone. Luc, you have the floor for the conclusion.
All right. No, thank you very much for leaving me the floor to conclude this very lively discussion. I think we touched upon a lot of issues that are very interesting and which we'll need to dig into deeper and further in our project. And I will say actually that the discussion derived quite interestingly from a focus on how to combine this legal perspective on one hand and legal debates on what's the function of vulnerability, how can it be defined in law, and on the other hand, this empirical discourse on how to analyze the complexity of migrants' experiences and what kind of concept can be used to really understand what's happening to these people. Now, I think there is a dimension, however, which we touched upon and which we should investigate maybe a bit further in our project, and these are the political uses of this concept. Of course, when one speaks about vulnerability, one gives a certain message, a certain conception of what a migration policy should be. And when one brings another concept with precarity, then there is yet another conception that comes in. And what I mean by that is that when there is this talk about vulnerability, there is this notion of deservingness, there is this notion of having a fair migration policy. And when one moves on to a precarity, maybe we keep this dimension of deservingness, that's something to be discussed, but we also bring in yet another dimension, which is the economical dimension, and what kind of economical gain, but also economical risk can be associated with migration. And so that will be just maybe my final thought here to close this very interesting discussion. And I thank the panelists very much for engaging in that conversation with us. It's a very challenging conversation. We've heard a lot of very challenging thoughts, leaving open, of course, the question of where to draw the line when one develops a migration policy that is selective by definition. But still, I think we had very interesting thoughts tonight, and I thank you very much for that. And I thank you very much the people who asked questions for their very interesting insights. So I give you the floor, Francois, if you want to.
Have a nice evening.
Have a nice evening, everyone, and a nice afternoon to Anna.
Bye.
Bye-bye. Thank you.